sometimes I question whether there's really a difference between international law and business law, because businesses right now, as soon as they hit the web, the internet, you're international. So it just means that anyone and any place in the world is able to contact you for your service or for your commodity, whatever it is that you're selling. As a matter of fact, the trend is just to be international and have whatever you're doing. It could be made in one country, shipped and assembled in a different country, and then forwarded to somebody who's in a totally different country than the one that you're in. So we're just in this international world. But from a practical point of view, contracts that are done nationally between companies, that's your basic corporate law. That's your corporate law. But when those start crossing country lines, now you're talking international. You're looking at treaties. So if there's a commodity that's going back and forth with what used to be known as NAFTA, where you were looking at commodities traveling between the U.S., Mexico, and Canada, now you need to consult those treaties. You need to consult those governments and look at how things have played out in different courts. Whereas if it's just nationally in the U.S. where I am, then you are just looking at what's happening in our federal courts or even in our local courts here. So international versus national, when you look at different subject matters, it becomes very, very important. But contracts are contracts, no matter where they're happening. You do always have to have a part of the paragraph on law. You're going to talk about what laws are going to apply. But even if you have a contract where it's between different people or different companies of different nationalities, you may have a law apply that doesn't really have to be specific to the jurisdiction. So what I'm thinking is you might have someone who you're doing business with in Illinois, but the actual law that you want to apply is the law of Indiana. And if both companies agree, then that's fine. You just make that contract so it applies to both of those, or however you want to do that. One thing that we like to make sure that we're doing is, if we can, avoiding the litigation. Litigation's a risk. Litigation, in the U.S. you have discovery, and you could be doing that and pre-trial for a number of years. So that's a business risk that could drain you financially. So when we're strategizing on what's the best approach to your business, litigation is one of the things that we try to avoid. So there's arbitration, there's negotiation. But if we have to litigate, we'll be there and we'll win.